Okay, well, hello everybody. Thank you for joining us. It's about 6:01, so we'll get started shortly here. Thank you everyone for joining the Iranian American Bar Association DC chapter for another one of our installments of a Know Your Rights event. So today we'll be talking about employment law. But before we get into the nitty-gritty of our substance today, a little bit about IABA and a little bit about our speakers. My name is Shirin Afsus. I'm the National Liaison of the IABA DC chapter, and I have the distinct pleasure of serving as your moderator today. I'm an attorney at Greenberg Traurig, where I handle employment law matters, and please be advised that the opinions expressed tonight are the opinions of the speakers themselves. IABA's mission is to educate the community about legal issues of interest to Iranian Americans, protect and advance the rights of Iranian Americans and other minority groups, promote and foster the achievements of Iranian American legal professionals, and fundraise for law students and scholarships. This year, IABA DC is putting on a series of Know Your Rights webinars and in-person meetup events, so please make sure to follow our social media channels to stay engaged. Now, I have the distinct pleasure of introducing our panelists. We are joined tonight by Roya Baseri, who is the founder of Baseri Law Group, where she focuses on employment law, civil litigation, and regulatory compliance. She represents clients in complex disputes and advises on risk mitigation, internal investigations, and workplace policies. Ms. Baseri is admitted to practice in Virginia, Maryland, DC, and New York, and has been consistently recognized for her legal excellence by Super Lawyers, Virginia Business, and Northern Virginia Magazine. We're also joined by Kia Rahnama, who is an associate in Fluids Litigation and Investigation and Government Contracts Practice. With experience across all three branches of the federal government, he has clerked at the U.S. Court of Federal Claims and held roles in the White House Office of Science and Technology, the Department of Labor, and the FDA. He advises clients on complex litigation, regulatory matters, government contracting, and has significant experience in motions practice. He earned his JD and MA in International Affairs from George Washington and is admitted to DC and Virginia. So thank you both for joining us today and taking time out of your day to speak to us about employment law matters. Now, before we get started going through the very distinguished topics that we're going to talk about, a little overview about what we're going to be addressing and the types of language and statutes that you might hear today. So we're going to primarily be focusing on federal employment law. We will be addressing some state-specific issues, but the basis of what we're going to be discussing will be the federal statutes. There are several federal statutes that are relevant to employment law, including Title VII of the Civil Rights Act, which prohibits employment discrimination based on race, color, religion, sex, or national origin. There's also the Fair Labor Standards Act, or FLSA, which establishes minimum wage, overtime, and child labor standards. There's the Americans with Disability Act, also known as the ADA, which prohibits discrimination based on disability and requires reasonable accommodations from employers to employees who meet certain criteria. There's the Family and Medical Leave Act, also known as the FMLA, which grants eligible employees unpaid job-protected leave for certain family and medical reasons. There's also Age Discrimination in Employment Act, also known as the ADEA, which protects workers aged 40 and older from age-based discrimination. And you may also hear about the National Labor Relations Act, or the NLRA, which protects the rights of employees to organize and engage in collective bargaining. Now, all of these statutes are enforced by federal agencies such as the EEOC, the DOL, and the NLRB. So as you can see in employment law, we have a lot of acronyms. Now, with that brief overview, I'd like to turn it over to our speakers, and we're going to start by first discussing some wage transparency laws that are coming up in different states now. So Roya and Kia, I'd like to talk to you about any specific pay transparency acts or statutes or laws that our listeners should be aware of that have come up in 2025.
Sure. Why don't I start, and then I know Kia has info on this too. So I'll start just broad national since the beginning of this year. So from January through the present, there's been several states that have passed wage transparency laws, including Illinois, Minnesota, Vermont, Massachusetts, and a locality, Cleveland, Ohio. Different, obviously different details for each statute and each code, but all aimed at wage transparency and different employee thresholds for having to comply with the statutes. Closer to home, though, we have at least one on the books in DC that I'll let Kia talk about, as it's more relevant to this area.
Yeah, so DC actually happens to be one of the geographic locations in the US where this trend towards improving wage transparency has really been strong. My background is more in litigation in this area, and even though having these laws on the books on paper sounds really good, requiring employers to disclose how much they've paid people in the past, or disclose what sort of benefits you would get if you get hired, or the range of salary is. Enforcing them is another question of, if you apply for a job that doesn't have all that information in there, and you happen to live in a district or state that requires the employer to have that posting, and you see that an employer that you want to work for is not really complying with that law, what do you do? It's usually not a great way to start your relationship with your future employer, by suing them and saying the job posting doesn't include that information. So the state attorney generals play a big role in enforcing these laws once they're on the books. And DC happens to be one of the geographic locations where the current state AG just issued an advisory in July, reminding businesses that the district is intending to enforce its wage and transparency laws pretty aggressively. So I think Roya, I don't know if it's rare that we have discernible trends in one direction, but it seems like most states are now opting for including some form of wage transparency law on the books, as there's more economic turmoil and employees are moving around. I think the only state that I've seen recently buck that trend has been Florida. But it's not unusual for Florida to be an outlier state on unemployment law issues.
Yeah, I was actually surprised. I knew that quite a few had been passed, but when putting together the information for the presentation, I was just given, and we'll talk about it a little bit more later, but kind of given the trends in employment law and the executive orders, I was surprised at the number, and I'm curious to see how enforcement plays out. So I haven't had the chance to deal with it personally on behalf of my clients, but I'm curious to see how this plays out.
Definitely. I mean, we'll talk more about pretty much all employment law issues now take on unique circumstances. When you talk about remote work, nobody really knows how the wage and transparency laws are going to play out with all the remote work situations, with people applying. If you post your position on Indeed, and you expect 50 people from 50 different states to apply to work remotely for the position, you have to comply with 50 different wage transparency laws. I would not be surprised if we get some kind of uniform guidance from the Department of Labor or the federal government in the future. But this is one of those areas where the employers are probably going to need a lot of legal counsel going forward.
Yeah, you mentioned the importance of enforcing wage transparency laws. Why is it important for state AGs to be enforcing wage transparency laws? What's the purpose of a wage transparency law?
I think it protects employees in terms of competing on a level playing field. I feel like it's not enshrined law, but I think it is. It is in the academic literature, at least, that different demographics have different propensities and skills in negotiating for what they should get in their employment. And I think these laws kind of serve the public interest by trying to ensure that the playing field is leveled a little bit. Now you do have this issue of concrete harm, which has always been a linchpin of federal litigation. If you go to court, you have to establish that you were harmed, and it's tough. In the absence of state AGs getting involved, it's really tough for job applicants to be able to sue to enforce these laws, because then you're asking a judge to analyze whether or not you would have gotten the job if all the information was transparent, or if there was another reason why your application never went through or you never got an interview. So it's I think the state AG roles, it's going to be interesting to watch.
Roya, do you have anything to add about the importance of wage transparency laws on the employer side?
Well, I agree with Kia that they're designed to level the playing field and close gaps in salaries between different groups. And for all the reasons that Kia just said, this is kind of exactly why I said it's going to be interesting to watch how these play out, just given kind of what's going on and what's happened since January of this year, to see whether or not there will be active enforcement, and then, will compliance with these laws have employers walking into liability pursuant to other, for example, executive orders.
Kia mentioned the DC Wage Transparency Act. What about in Virginia? Isn't there a Senate Bill 1132?
Yes, not law, but there is a pending legislation to have the same in Virginia, or have similar wage transparency in Virginia.
And do you expect that the Senate bill will pass in Virginia and become law?
Ooh, we're making calls. I don't know, Kia, do you have a guess on?
Look into the crystal ball here. I think so too. Yeah, I think
it's been more and more
like
employee friendly. Sorry, yeah, just
definitely.
Yeah,
no. I agree. I guess it's strange, but we would put probably the practitioners in the area would put Virginia on the employer friendly side on a lot of these issues. It doesn't. It would at least track with their position on, I guess, the other significant trend in state employment law, which is the enforcement of non-competes, and that's also an area where Virginia has been on the employee side rather strongly, and I can see them endorsing a strong wage transparency piece of legislation in line with that attitude.
Virginia has certainly been shifting a little bit from a employer-friendly state to a much more employee-friendly state. So it will be interesting to see how trends are going to be shifting as things continue to move forward. Another area which practitioners, companies, and employees are all looking at very carefully are non-competes. I'd like to hear both of your opinions on the recent news out of the FTC relating to non-competes and how they may be impacted going forward. And Kia, let's start with you. And if you wouldn't mind also giving a little bit of background about what a non-compete is and how it impacts employers and employees. And then we can talk about the FTC issue.
Sure, yeah. A non-compete clause in an employment contract effectively tries to protect what an employee might take away from a place that they're working for when they decide to leave and go to a new place to work for. I think it's become it's taking up more space in employment law because the tech industry is so big in the US now, and that's at least from our experience, it plays a big role in switching and transitioning from job to job in the tech industry, because trade secrets and institutional knowledge are so important. But it's not really limited to the tech industry solely. I think Chipotle was in the news this last year for trying to prevent its employees from leaving and going to other restaurants and taking all of the secrets about how to make delicious burritos. So it's definitely another burgeoning area of law. The trend here has been to, for at least from the courts, from the state courts, to be hesitant in enforcing these non-compete clauses, out of the understanding that they really slow down the job market and they really do not serve the employees at all. It's not unusual to see a non-compete clause in a contract that effectively enforces an employee to wait 60 to 90 days before switching jobs. We've had I'll let Roya speak a little bit about the drastic shift in perspective at the federal level, which has left pretty much all of us in a limbo in terms of what kind of advice we are to give to the employers who wish to have these in there as a part of their employment practice.
Sure. So I will say that I represent both sides on employment, but on this issue, while I write the agreements for my employer clients with the eye towards enforceability, I am often defending the employee who has been accused of breaching a non-compete. So a lot in Virginia, but also in Maryland and DC. And it is sometimes heartbreaking to see how a bad agreement can get by because people can't afford litigation, but I'll get off my soapbox. So in 2024, the FTC enacted a nationwide ban on non-competes. This was all the rage. Everybody was talking about it. I spent a year learning about the proposed rule, the final rule, and then there was an injunction banning the rule being applied. As of, and maybe this is what you're referring to, Shireen, as of September 5th, this administration's FTC has abandoned the appeals of the injunction. So they were pursuing appeal, they've abandoned. But I don't know that the FTC has completely changed course on this because they're still going after overbroad non-competes. And they recently, I think just the day before, the appeals were dismissed on September 4th. They put out a public inquiry about non-competes. So I don't think that the discussion about non-competition agreements at a national level is over. In this area in Virginia, and also there's been updates in DC and Maryland, but I'm in Virginia, so I'll start there first. Shireen, you said just a minute ago or a few minutes ago that Virginia has become much more employee friendly, and Kia, you touched on this as well. One of the things that changed this year with non-compete, so we recently, Virginia enacted a ban, or in the last few years enacted a ban on non-competes for low-wage earners. And low-wage in Virginia changes every year, but currently it's about just over $70,000 a year. As of July 1st of this year, that prohibition on non-competition agreements also applies to anybody who's eligible to earn overtime, which is a huge change. And also, in my experience, it is very difficult for employers to understand who is eligible for overtime and who isn't. That's a whole nother issue. So another change that'll be interesting to watch play out. But DC, Maryland, and Virginia all have some version of a prohibition on non-competes depending on salary and profession.
Before we move on, you did touch on something that I think our webinar participants might be interested in. You said that it's sometimes difficult to determine who may be eligible for overtime versus not. Can you expand on that a little bit? Because this is an issue that comes up quite a bit, especially in classifications employees.
Sure. Depending on what kind of, how sophisticated an employer is. I mean, this is why I think it can be difficult. If you're a small business and just any, honestly, any business, if you're not staying on top of the laws, if you're not keeping detailed job descriptions, because the way that you determine an employee is eligible for overtime is based on their duties and their job descriptions. And often in my experience, and I'm at a smaller firm, I'll have an employer come to me and say, well, the employee said that they just wanted to have a salary, so that's okay, right? That I don't have to pay them overtime. And then I cry on the inside and tell them why that's not okay. And we go through and we figure out what, we go through the duties and see if they're actually supposed to be can they be exempt or are they eligible for overtime? And then we work backwards to fix it if there's been a mistake. But it's job specific. The analysis is position specific. And that also was something that last year there was a proposed change. And again, we spent not all year, but a good amount of time preparing our clients for said change. And then that change did not, it was halted. So.
Yeah, how do you deal with any overtime concerns with federal employees? Do you ever run into this issue with your practice concerning federal employers?
So I don't represent.
No,
Yeah.
yes.
Yes, it was for Kia, right?
Yes.
Yeah, federal employees, I think the most significant issue from the Fair Labor Standards Act this year is probably going to be where FLSA lawsuits are going to be brought. There's been this ongoing dispute between district courts and the Court of Federal Claims, which is a specialized court that only hears disputes involving federal government having to pay somebody money damages. And this has been an ongoing dispute for 10 years now, whether or not federal employees should go to the Court of Federal Claims to enforce the FLSA, or if they can file lawsuits in the district courts. We're anticipating that the DC Circuit, whose opinions matter a lot in the areas of federal employment, is going to have to address that issue this year, and it could have a significant impact on where federal employees could file lawsuits against the federal government. The other issue is obviously going to be, it's kind of tied in to the classification issue. Obviously, with the mass reduction in force happening this year, a lot of federal employees who used to work for federal agencies as Title V, bread and butter federal employees, are now being rehired after being RIFed, but under different classifications, sometimes as independent contractors, sometimes as personal service contractors. And it's never been completely clear on what the federal government's FLSA obligations are for employees that are not classified as traditional Title V federal employees. And because of the mass RIF that occurred this year, and a lot of federal agencies reclassifying traditional positions, we're likely to see a lot more activity from the federal courts trying to clarify whether or not you have to be a traditional Title V federal employee to be entitled to FLSA or not.
Yeah, before we move on, you mentioned a couple terms that three of us know well and other practitioners might know well, but I want to make sure that all of our attendees do as well. What is a RIF? What do you mean by that?
So a RIF is a reduction in force. That's when a federal agency determines that a position that's always been at the federal agency no longer serves the agency's purpose, doesn't promote the public interest anymore, or maintaining the position could constitute waste of federal resources. Various reasons not directed at the employee itself, but the position, that might lead to the federal agency deciding to eliminate the federal position. And obviously with the federal position goes the federal employee who is filling the spot to carry out the duties required for the federal position. So beginning this year, as a part of budget cuts, effectively, we had a series of really unprecedented and large reduction in forces happening at every federal agency. And the disputes about laying federal employees off in that matter, and whether or not then you can rehire them for similar positions, but under different classification is still ongoing through the federal court. So we'll have to be watching the case law develop this year.
Why is that important under the federal laws? What employees are classified as? Why should we care how the federal government specifically, as we're speaking to you, Kia, given your expertise, why should we care how employees are classified, whether they're independent contractors, whether they're Title V employees? Why does the classification matter?
So it matters as a kind of a creature of bad legislation, unfortunately. So these different classifications have historically existed for as long as we've had a federal workforce. We've had different classifications for federal employees. We've always had Title V employees. Those are federal employees that are appointed to federal service and get a position title, but the federal government has always historically relied on contractor work to fill out temporary positions or federal positions that are not directly funded by Congress, but the president might need something to be done. So you hire a temporary workforce. So that's always been there. And then against the background of that multifarious classifications, we've had Congress pass all of these laws like the Fair Labor Standards Act that gives employees certain entitlements and benefits, but most of these laws don't actually define what kind of employee is supposed to get those benefits. So because the internal language of a lot of these federal employment legislation is unclear on whether or not Congress intended to cover everybody who's working for the federal government in any nature or form, or just a specific special set of Title V employees, the classification issues have always been hotly debated, because with your classification goes your entitlement to this huge field of entitlement and benefits.
Roya, what about in the private sector? Why does the classification of an employee matter for employers and for the employee themselves?
So like Kia said, benefits, right? Benefits available to the employee, whether or not they get overtime, whether or not they're eligible to, for the individual, whether or not they're eligible for the other benefits that if they're classified as a contractor, are they missing out on the benefits that an employee is getting? But also the withholdings. So I'm not a tax attorney, but the company is paying taxes are coming out of your paycheck. If you're a W-2, if you're a contractor, you're responsible for it on your own, and the employer doesn't have to pay anything. So it might seem more attractive to try to insure employees into the independent contractor bucket, but it can be problematic down the line if it's not done correctly.
We're also talking about why classification might be important, relevant to the non-competes. So going back to what you were both saying concerning enforceability of non-competes, let's talk through what the court will look at if an employee wants to challenge a non-compete. And we can start by looking under Virginia law, because these are very state-specific issues. What are the types of things that the court may consider when deciding if a non-compete is too restrictive or if it shouldn't be enforced? And Roya, we can start with you.
My favorite. So the general, like very broad rule is the court's going to make sure that the employer actually has an interest in this person not competing and doesn't an interest tied to the business, not just the employer doesn't want the person to compete. They just want to squash competition. So what was the level of this individual? What access to information did they have? What inside proprietary information did they have access to? How close was this individual with the customer base? Do they take with them, the company's goodwill when they go to another company? Those are some of the things that the court will look at. Also, this, for at least for Virginia, but other jurisdictions as well, like the duration, how long is the prohibition on working for a competitor, the geographic radius. Are you saying within 5 miles of anywhere where the individual worked? Or are you saying within 100 miles? And then all of that really has to take into consideration the level of employee, right? Are we talking about somebody who works in a fast food restaurant, or are we talking about a high level person who basically was developing business development strategy for the employer? Those are, two different analyses.
Yeah, you mentioned the use of non-competes by companies like Chipotle to make sure that their trade secrets didn't get out. Do you want to elaborate on how non-competes can be used by employers to safeguard some of those proprietary issues?
Yeah, definitely. I mean, you see this in the court cases involving non-competes all the time. It is not, it recently it is really tied into trade secrets violations and those kinds of claims. It's not unlikely for a court, even though there's a trend of not enforcing these non-compete cases, given a specific industry, given a specific company, it's not unlikely for a judge to decide to enforce a non-compete clause when the two companies that are involved, that the employees hopping back and forth with, are involved in high profile trade secret litigation. And the trade secret litigation happens to be about an issue that you can actually discernibly see would cost one of these companies a ton of money if their employees were to leave and take that information to a direct competitor. So I think it's an area of uncertainty, but I think state judges are very shrewd in figuring out these cases of like, is this really, does this specific business really need to have a strong non-compete policy enforced throughout, or is it just something that's being used by employers to slow down employee transition and effectively keep employees trapped? And I mean that it's even when employees might not be necessarily, even in cases where employers might not be able to enforce the non-compete clauses against their own employees, there is a trend of keeping them on the book just in a case of a company suing another company for a trade secrets violation, and you tack on in your lawsuit that, look, oh, they also hired so and so from our company, even though that individual had a non-compete agreement with us. So you can present that as an interference with a contractual agreement between you and your employee, even though the fight is really between two companies. So it's become a cudgel for competitors to go against each other. Yeah.
Would you agree that most non-competes nowadays also include non-solicitation provisions to prevent exactly what you're talking about?
Roya, what do you think? I tend to see a lot of cases where those two things are kind of bound together.
Yeah, they're kind of all in the same agreement. Non-solicitation. If there's no non-compete, there's a very stringent non-solicitation that effectively acts as a non-compete. And then there's, because you can't go anywhere given the non-solicitation restrictions. And then there's the confidentiality and proprietary information portion that relates to the trade secrets.
There definitely seemed to be a trend, as we were talking about some of the legal trends, there definitely seemed to be a trend in the past few years of allowing employers to really construct pretty severe non-competes and non-solicitations. And it seems like states are trying to rectify those stringent requirements now. We talked about Virginia's changes effective July 1st, 2025. Are there any changes that we should be aware of in Maryland, for example, also that were effective July 1st, 2025?
So Maryland had low wage, a ban on non-competes for low wage earners. It was much lower than Virginia's. Well, I can't do the math. It worked out to 22. It currently is 22.50 an hour. In the past 2 years, so last year, I believe they added an exemption, or they added medical professionals this year and vet techs last year to the non-compete statute, or the ban on non-competes.
We actually have a question from one of our attendees specific to non-competes. The question is, weren't many non-competes done away with during the pandemic? During the pandemic, would either of you like to opine on what happened to non-competes, as a lot of people were reacting to their jobs changing or shifting? Roya, let's start with you.
Sure. I don't know that I agree with that. I can only speak from my experience. I don't know if they were done away with in this area or just not, you know, there were bigger fish to fry and they were, you know, employers were focused on other things. I will say that even in, I think in the first year of COVID, I had a preliminary injunction hearing on a non-compete case for a not high-end person, you know, like not a high earner. It was a very interesting case, but I don't know that they were done. I mean, they certainly weren't done away with by any legal mechanism. They just maybe were not enforced.
Yeah, would you like to add any opinions on that?
No, I mean, I share everybody's confusions because this is one of those areas of law where things have been snapping back and forth. But I mean, I think the Biden administration was strongly against enforcing these, and they were ready to put their foot down and try to have the federal government be involved. But now we're back to this area of uncertainty. And I think it's interesting because from the employer's perspective, even there's a lot of you observe these new trends that are supposed to be kind of a replacement for achieve the same goal for a lot of companies that a non-compete clause would. So one of the big topics recently has been the emergence of these are called training repayment agreement provisions. They're actually aptly called traps, which is very funny, where your entry to the company is conditioned on paying for trainings that would really prep you for the position, and then your contract might include provisions that force you to pay back the cost of the company having subsidized your training to learn skills if you decide to leave the company. It's not uncommon for big companies to offer employees now to help them with their tuition assistance, to their relocation, and a lot of goodies up front effectively. And in the states where non-competes are harder to enforce, this has kind of become a mechanism of achieving the same thing. Employees decide to leave, and all of a sudden the company's like, well, not until you pay us back all of the money that we paid for you to get this certification or for you to relocate, or the tuition assistance that we gave you. So I mean, the change is it's discernible enough that I think, I don't know, Roya, if you think so too or not, but we eventually have some kind of a strong federal position on this issue soon. I think the current administration is just trying to test the temperature because it's a complicated issue.
Yeah. Well, from my recollection of the deep dive that we all did into the FTC rule it banned anything that was explicitly a non-compete or looked and smelled like a non-compete, right? So it wasn't just non-competition agreements, but it was broader than that. I think what remains though, and what is constant, is that you're able to, and maybe this is, you know, an area to focus on for employers, you're able to protect your trade secrets and proprietary information if it is truly not public proprietary of value to the company. So focusing more on that, while I understand it is much easier to have a non-competition or non-solicitation clause to protect that information, maybe focusing more on tightening up the proprietary information, trade secrets related clauses of the agreement, confidentiality, in the face of what we're watching kind of slowly happen to non-compete agreements.
So it sounds like, if both of you agree with me, best practices for employers is to have an employment attorney who is very closely watching what's happening with all the federal regulations as well as what's going on in each state, because an employee may move from one state to another state and the laws may completely change specific to their non-compete. And on the employee side, before signing a non-compete or something that looks like a non-compete, they should have an attorney at least put some eyes on it. That sounds to be like the best practice that both sides should be participating in, given the changing landscape. Is that right?
Agree.
Always good to have a lawyer on the call. Ideal. So yeah, definitely. We always recommend having an attorney on the call.
We've been talking a lot about the shifting landscape, so let's maneuver away from the FTC and the non-compete issue, and talk about some recent case law that's come out in 2025 that is impacting employers and employees. The most relevant of which has been the decision of Ames versus Ohio Department of Youth Services. So just a little bit of quick background, and then I will turn it over to our two panelists. This is a Supreme Court decision that came out roughly 2 months ago, and it's a decision that rejects a heightened evidentiary burden for a plaintiff who is a member of a quote unquote majority group under Title VII of the Civil Rights Act. So basically, claims brought by a majority group plaintiff are sometimes referred to as a reverse discrimination matter. An example of this would be a member of a minority group who would have normally brought a lawsuit saying that they were being discriminated in some manner because of their minority status. This now flips it on its head. So Kia, let's start with you. What do you think the Ames decision changes in terms of the landscape of reverse discrimination claims in the federal workforce?
Definitely, Shane, I think you did a great job summarizing it. I think it's definitely a signal from the high court to the district courts that the high court is seeing the landscape change, and they're effectively telling the district courts that what they perceive to be the current administration's views on enforcing anti-discrimination laws is probably going to be acceded to by the high court. Roy and I were just last week, we were talking about the EEOC's position that, I mean, everybody's following the H-1B visa issues in the news. And I think the acting EEOC just last night used the X platform. I'm not sure if you can say tweet anymore, but she tweeted that that the EEOC is committed to using the Title VII discrimination laws to protect the American workers. So even in describing the background law, I think you mentioned the term minority groups. That's how historically it's been understood, the main beneficiaries of Title VII. And I think this is a change in that perception, which is you don't really have to be a minority group by the traditional definition to have a valid discrimination clause. So the EEOC's position on the visa issue, for example, is that they're going to go after companies for exhibiting anti-American worker attitudes, openly stating that visa holders or people born and raised outside of the United States might be more suited for a certain position because they work harder or because they bring a special set of skills with them from outside of the United States. And it's definitely new and fresh. It's a fresh perspective. So, but the Ames decision, I think, is probably the most significant employment decision that we've had in the last year.
And Roya, before I turn it over to you, just very brief background about the Ames decision is that the Ames decision was focused by a plaintiff who was, by all accounts, in the majority group. She was a heterosexual Caucasian woman, and she brought this lawsuit alleging that she was not considered for a promotion despite being qualified for that promotion, and the person who obtained the promotion was an individual who was a homosexual female. And so this was really the first time, as Kia was mentioning, that the court was looking at this reverse discrimination issue where the person who's bringing the lawsuit is someone who's quote unquote in the majority group. So Roy, I'm going to turn it over to you with just that little bit of background for attendees. How do you think this is going to change Title VII litigation moving forward, given the signal, as Kia was saying, that the High Court is giving to everyone?
Yeah, so I think that these cases were out there. Like, I received calls for some cases like this, but this is very obvious. There's going to be a rise in cases where it's a member of the majority group utilizing the protections of Title VII. But I think that the cases were out there. It's just maybe we were not everybody was taking them and didn't think that that was the intent of the statute. Yeah, so definitely a rise in cases, but I think that this is, without making any call on whether it's the right decision, it is in line with everything that most things that we've seen from the administration and we might talk about it later, but the emphasis on dismantling DEI and eliminating quotas and not giving preference to one group over another, even if that means not giving preference to minority over majority. So it is in line with what we've seen.
So shifting now to DEI, since you mentioned it, how are you seeing the recent executive orders from the administration impact DEI? Are you seeing that there are evolving legal standards now within the workplace and how employers can deal with the DEI issues? Roya, we'll start with you.
Sure. For my world and what I deal with, and I saw actually a question that I'm kind of going to talk about in my answer to your question, Shireen. I've been advising employers to, if they're concerned about the emphasis on shifting away from DEI, to review their manuals, review their policies, and make sure that there's no not just that there's no mention of DEI, but to make sure that their programs and their policies kind of keep in line with what we saw in the Ames case. They're not promoting one group over another, and are focused on fairness, I guess, and inclusion rather than preference for one group over another. That's where it kind of the extent of where it is in my world currently. I know it has there's been different implications in the government and for government contractors.
Yeah, how are you seeing the impact of the DEI related executive orders impacting federal employees, since that's more of the group that you deal with?
Yeah, for government contracts, it's definitely causeways effectively. We had a big Supreme Court decision this year, United States versus Cosessis, involving a federal contractor that had procured a contract with the federal government under the promise that they would have a subcontract agreement with a company from a disadvantaged background, and they got the contract. They made an arrangement with the subcontractor from with the disadvantaged background. They turned in their work to the federal government. The federal government loved their work. Later on, the federal government figured out that the subcontractor did no work. They were just a pass-through entity, and it made its way all the way to the Supreme Court, because the question was whether or not the federal government can sue a company for fraud when there's been no economic harm, because they ended up liking the end product. No, there was no question about that they were satisfied with the government contractor's work. The only issue was that the contractor had promised the federal government that they were going to use a disadvantaged groups as a subcontractor, and they really did not. And the court said yes. They said you're effectively defrauding the federal government when you make a statement to the federal government about how your business is operating, and that statement turns out to be not true. So in an environment where the DEI executive orders have been issued and set certain requirements for federal employees across the world, I think decisions like this take the internal practice of the company beyond just statements. That if your work involves working with the federal government, you need to make sure that you're complying with the executive orders, regardless of whether or not you think complying or not complying with the minutia of what constitutes DEI work or workforce effectively harms the federal government or not. It's the added on of fraud investigations being added to this definitely makes this a very high risk area for employers.
One thing that we've been speaking a lot about is the various changes, either at the state level, the federal level, or through executive orders that have impacted employment law this year on the employee side and on the employer side. And one thing that likely all of us have seen has been the impact on free speech and private speech, and how that speech may be impacting employment opportunities and a person's current employment. Kia, we'll start with you. What do you think about how employers and or employees should be handling maintaining their freedom of speech, and maintaining being able to have their opinions, but also not having it impact their ability to maintain their employee.
Yeah, so I mean, the protections are broader for federal employees, obviously, because the First Amendment protects against restrictions of speech by the federal government. So that's usually the first thing that we have to clarify for clients, employer side. It's obviously that there's been a lot in recent news about people being fired for their statements on their social media or during wartime. The question has always really been to what extent for private employees, the question has always been to what extent can your statements be really traced to your work. So it's always good to be mindful of whether or not you're posting things on social media on duty, off duty, whether or not you're logged into your government or employer issued laptop while you're making these statements. I'd like every other area of employment law. I think it's ultimately the legal issues are resolved by looking at totality of circumstances. But I think for private employees, the thing to keep in mind mostly is whether or not your statements can be traced to your employer in any way. I mean, this has become a bigger issue with remote work because people happen to be working from home, and that you're at any minute of your day, you're kind of working and also not working at the same time. Which increases the risk of, like, I mean, it's in these, the cases are very interesting because a judge will look at the timestamp of your social media post and try to see whether or not your employer made the right decision in terminating you based off of you tweeting something at 11 a.m. when you should really be working. Why were you on Twitter to begin with? But Roy, I don't know what you want to add. I mean, the other aspect of this is if the union work definitely is implicated in public statements because the National Labor Relations Act protects speech that's meant to improve your working conditions. Roy, have you worked on these issues?
Not, well, our firm does, not me directly,
Yeah.
but I know that there are numerous recent, in the past few years, board decisions about things that you might at first glance think, oh, definitely the employee should be fired for saying that. But if it was tied to protected activity under the NLRA, then, then they're allowed to say it. I was going to make a joke about just don't say anything, but that's not helpful guidance. But yeah, definitely in the union context, there's more leeway if the speech is protected under the NLRA.
It definitely seems to be great guidance in this day and age right now. Do you both think that as these issues continue to develop, employers will need to address, at what point someone sends a tweet during the day specifically, or any specific policies about personal opinions during the workday? Or I don't know if you want to take this, if there's any policies that you'll see employers implementing to make it a little bit of a brighter line.
I mean, honestly, like the way that we work, and this is just my opinion, not based on any of like the clients I've dealt with, the way that we work and the hybrid or completely remote, even in the office, I just think policy or no policy, for very few jobs, can I picture someone like having their phone down and completely not doing anything personal during the workday. So I think it's going to be really interesting to see how it plays out. But yeah, I don't know if he has any thoughts on that, but I don't know that it's abnormal for someone to have an 11 a.m. tweet or text message, because I feel like we're constantly connected, even more so since going mostly remote.
Yeah, what do you think?
Yeah, I mean, I just think it's one of those areas of law where both employee and employers working together can avoid a lot of disaster scenarios. Good training on the employer side about use of social media, and also kind of employees being mindful of don't use your work computer to log into your social media account. Or I mean, be mindful of the fact that even political speech online today is different than 15 years ago. There is an amplification that where your statements could really go viral in any minute and actually do become a national story. I mean, in that case, it's in those cases, it is hard to completely be on the side of an employee if a judge, for example, can see that something that you posted that garnered national interest actually did end up hurting your employer's bottom line. Sometimes those impacts are measurable because of how viral statements can go these days. And in those, just because those scenarios are possible, I think employees need to be a lot more mindful of public statements online.
Great advice by both of you. So as we've been talking about, policies and procedures, we actually have a question from an attendee about what subjects are being added or rewritten to employee handbooks, or expect to be rewritten or added to handbooks in the future. For example, AI use is becoming a big thing, both for government and non-government employers and employees. Roya, why don't we start with you? What do you think some handbook changes that we're all working on and coming out soon?
Yeah, besides scrubbing your handbooks and anything that might be seen as illegal DEI, I think the AI policies are becoming more prevalent in any sector. So we've all, like, as attorneys, we've heard the horror stories, and I don't need to go through them about, fake cases, but just that the information that's being put out and made public or potentially made public from employees needs to be regulated. So I've personally dealt with in my practice, AI policies. I don't know if, Kia, there are others that are top of mind for you.
No, I was just gonna also joke that this is one area of law where maybe the attorneys are not suited to give advice anymore, given how many recent cases there have been of
all the
attorneys.
violations.
Yes.
So it definitely sounds like the big takeaways from our conversation are employment law is a rapidly changing landscape, both from the statutory perspective. There's a lot happening at the federal level. The Supreme Court is doing a lot, and states are also doing a lot to, it sounds like, clean up where the gaps are between what the federal regulations state, and where states believe people, both on the employee side and the employers, need protection. And then we also need to stay on top of the executive orders as well. Kia, Roya, any closing remarks that you would like to leave our attendees with about any of the topics that we have addressed today? Roya, let's start with you.
I mean, I would just say to the employers, if they're not going to get an attorney, which I understand, there's a cost to it, to just try to keep up on the law and read. And for the employees, for the non-competes, that's the topic that's near and dear to my heart. Even if you're not going to get counsel, just to make sure that you're reading and you understand what you're signing up to. So because no one's thinking about their exit when they're on their way in, and they're so excited to start, a new opportunity. So I would just say, read your documents. Sound advice.
Yeah, what do you think?
No, sure, and I agree. I think it's we would just say due diligence for both employees and employers. Sometimes knowing that there's not a clear answer itself is an answer. It guides your behavior and conduct. Knowing that anything really could happen. Sometimes it's debilitating. Sometimes it's helpful. But yeah, I mean, we're keeping track of all of the developments. We're at least live in interesting times.
For sure.
At the very least. Well, we are right at time. I want to take this opportunity to thank our fantastic panelists. Kia, Roya, thank you so much for joining us today and speaking about this rapidly changing landscape with a lot of landmines, it sounds like. But thank you both for taking the time, and to all of our attendees, thank you so much for joining us for another installment of the IABA DC's Know Your Rights seminars that we've been putting on. If you are not an IABA DC member, you should definitely become a member. We have great programming, and you should follow us on social media. We have a lot of fun events, so make sure you follow us along. But thank you both so much for taking time out of your Monday to speak to us about these issues. We really appreciate it.